This is the second mini lecture video continuing on from the POAs and Advanced Care Planning U of T course 2019 PowerPoint. And we are on PowerPoint slide number 7, which is entitled broadly 4 types of powers of attorney. And this will focus on the language that we use, but also the typology of powers of attorney. So I've given 4 kinds here, and there's an asterisk beside number 2 and number 3. The first one is what we call a general power of attorney. What I really mean is it's a document that starts right away and then doesn't continue on. I'll show you that in a second. Numbers 2 and 3 are continuing and springing, and I use the language continuing. That's the Ontario language. In other jurisdictions, it may be considered an enduring power of attorney. A springing power of attorney, sometimes called a triggered power of attorney, and then we'll go to limited. But let's take each one of them one by one. So turning to slide 8, you'll see something that says general POA, and you see an arrow which starts at capable and ends at the point where there's a vertical line between capable and incapable. And I truly haven't seen one of these old powers of attorney in probably 15 or 20 years. But some people may have really old ones kicking around. And so usually these documents were created decades ago before we had easy ways of having portable money. So if I was going to go to the grocery store to get groceries for my grandmother because it was snowy and she was frail, I could take this general power of attorney with me and her checkbook, and I could go to the grocery store and I could buy her groceries with the checkbook, which seems extraordinary, but you could do that back in the 80s. And I could show the power of attorney, which gave me authority to sign her name. And this was just a document for convenience. But as you see, it doesn't continue on into the point of incapability. So it doesn't help you. It doesn't help you if you're trying to plan for if someone becomes incapable. So let's move to the next slide, which is slide number 9. It says continuing power of attorney. For those of you outside of Ontario, please consider using the term enduring power of attorney. And if you're in BC, Yukon, and some parts of Nova Scotia, with regards to the new legislation, you may also consider using the term representation agreement if you're referring to the personal and health care. But for those provinces as well, it can still be a continuing or enduring power of attorney if it had to do with finance. So let's take a step back. What's different about this one? Well, it starts right away and it continues on past that point where you're in a coma and you're into the point of incapability. And you see that as a capable adult, you get to make decisions about how your power of attorney is being used. And if you don't like how it's being used, you can revoke the power of attorney. But if you're past the point of incapability, then you can no longer easily revoke that power of attorney. It would have to go to court, usually in most jurisdictions, to have it revoked, unless that person is willing to step aside, which they often aren't. So what's important about the continuing or enduring power of attorney? This is perhaps the most common document. This is the one that most people have and most people want. So it starts right away and continues on later. Now, why would people want to have it start right away? Well, you could be traveling. You could want to have your spouse go down and renew your car insurance for you. You could want your adult children to get used to knowing where your accounts are, or you could just find it convenient to have it start right away. You could have an understanding that they're not really supposed to use it, or you could give them an understanding that they can use it if you want. So an example would be, I'm going to Florida for 4 months. That is not true. I wish it was true, but it's not true. I'm going to Florida for 4 winter months, and I want to have my adult child be able to run my finances and pay my bills here in Canada. So they could use my enduring, continuing power of attorney and be able to pay those bills on my behalf. Or alternatively, I'm going on a trip to Cuba, which is also not true, but it sounds nice. And if I'm there, I want to make sure that my best friend is able to help me if I get into a car accident in Cuba, and she could make healthcare decisions for me. So that's usually a good idea to have as a document that really can be used on a very flexible basis. Turning to the next slide, which you see is slide 10, it says springing power of attorney. Some people call it a triggered power of attorney. And this is a document that sleeps, right? It's not active and then springs into effect upon a certain event. Typically, it's upon some type of determination of incapacity. It could be for something else. You could say that you want it to spring into effect if you're kidnapped and ransomed, but typically it's mental incapacity. So some people use that document because they don't want anyone to be able to mess around in their business, and they will only want it to spring into effect when it's being used. It sounds good. Sometimes it's really hard to spring, particularly if you say that Dr. Jones from Smith Street is going to spring the power of attorney, and Dr. Jones is long retired or has passed away or no longer lives on Spring Street. So, excuse me, I'm a bit sick still. So springing powers of attorney have their pluses, which is to say you've got extra control over your own decision making, but it's got some minuses too, which is to say that you have to make sure it gets triggered, and sometimes people don't want to get the capacity assessment to make it triggered, or it can be challenging if you've been too specific in the document about how it needs to be triggered. I include limited powers of attorney in here too, just as a kind of a point of reference. You've probably done a limited power of attorney at some point before without really thinking about it. So if you need to renew something and you turn the paper over and you say, my spouse or partner or my friend or my sister can renew it on my behalf, and then you sign the document and you say they can do it, that's a limited power of attorney. It means they can do one thing or some things for a short period of time. So for instance, if I was going back on that trip to Cuba, for instance, and I wanted my neighbor to be able to make financial decisions for me for the period of time that I was in Cuba, because I want them to be able to pay my bills, then I could give them a limited power of attorney for just that 1 month. That's an example. I'm going to move along to slide 13, so skip over that one slide, which has got examples. I put some BC examples in there, but let's move to who makes your personal care decisions if incapable, which is slide 13. Now, I'm trying to put all of the different jurisdictions in this country into one slide, so you'll see that I have some notes on there where it says BC as an example, and some things are in brackets. So let's go down it. It's the same thing. It's the same nexus of incapacity. It's the same. If you're capable, then you get to decide. If you're incapable, then this is showing you what happens. Now, different jurisdictions in the country have a different, slightly, system for default substitute decision making, but they're kind of mostly the same. Broadly, for those of you who play bridge or euchre, there's a trump card, which is a guardianship, which are fairly rare and expensive and often quite acrimonious to get. And that's if a person goes to a court and gets a decision from a judge appointing them to be the decision maker. These are often tens of thousands of dollars to get, and can be a really an emotionally challenging circumstance, but is really the top decision maker. If there's any other competing people or different interests, if a judge appoints you upon an application to that judge to be the decision maker, then you're it. After that, and in bold, you'll see that the number 2 is a power of attorney for personal care or a representation agreement. In some jurisdictions, it might be considered a slightly different term, but it's going to be a power of attorney where you're making healthcare choices. In Ontario, it's considered a power of attorney for personal care. I want to just skip over the consent capacity board. That's an Ontario specific thing. I want to come back to it in a minute. So if you don't have a guardian, and you probably don't, and you don't have a power of attorney, then what happens? Well, let's say you're in that car accident and you get hit and you're in a coma. So it would go to your spouse or partner first if you didn't have power of attorney or a guardian. And your spouse and partner can be same sex. It doesn't have to be married. It can be common law, and that's fine. If you don't have a spouse or partner, we'll go to adult children, right? So over the age of majority in that province or territory. Now, it's important is that children are all ranked equally. So if you have 5 adult children, they could all be the decision maker, and they all need to come to an agreement amongst them, which can be a real challenge for many people. Then it goes up to parents. Well, don't think just because this is an older person that they don't have parents living. I had a case where I had a 72-year-old man, and I had to find his 94-year-old father to make the substitute decision making decision that needed to be executed in that particular case. So it's less likely they're going to have parents, but it doesn't mean that they wouldn't. And again, ranked equally. And then it goes down to siblings, and again, ranked equally. In BC, I make a note that grandparents and grandchildren have specific rankings in here that some of the other provinces don't have. And then it usually goes to any other relative by birth or adoption. In BC, there's also the opportunity for a close friend. And there's some definitions about what a close friend is. Now, I just want to go on to the next slide before we break. And the next slide is who makes your property decisions if incapable. So the slides we looked at before were about your body, about your health and personal care. And you'll see the slide is very different. Again, if you're a capable person, then you decide. If you're an incapable person, guardianship, which is rare, or power of attorney for property, which is much more common. And then after that, there is no default substitute decision making. So you see there's a gap there between 2 and 3, and that's because it would go down to the public guardian and trustee. Now, it's true for the personal care decisions at the very, very, very end. If there's nobody else, and for some unbefriended older adults that's the case, then it will also still go to the public guardian and trustee. But it's much more common for there to be somebody in a default substitute decision-making list for health and personal care. But in property, if you haven't made a power of attorney, or you haven't appointed a court-appointed guardian, which will be rare, then if you don't have a power of attorney, it's going to the public guardian trustee, and they're going to have to try to find somebody to help sort it out. And we'll continue on in just a second with our next mini lecture, continuing on this PowerPoint presentation.